Please be seated. We just have one case on our docket to be heard this morning, CSX Transportation, Inc. I might mess up that last name there, Mr. Baker, so.
It's Vosica.
Vosica, okay. I'd rather you say it than me stumble over it. Well, is the appellant ready to proceed?
May it please the court, my name is Charles Bell, and I represent the appellant CSX in this appeal. I'd like to reserve 4 minutes for rebuttal, if that's okay. The issue presented by this appeal is actually quite simple. Whether the trial court abused its discretion by requiring CSX to provide Vosica with his own private grade crossing without requiring Vosica to shoulder the liability risks associated with the private grade crossing. And the question comes down to, under the statutory way of necessity recognized by the Florida legislature, what the word compensation means in that statute. Fortunately, this court answered that question more than 4 decades ago in the Stein versus Darby case, when it found the statute constitutional and held that it was constitutional precisely because it required the dominant estate to provide full compensation in exchange for the statutory way of necessity. So the issue is, what does full compensation mean? And if you look at what Florida jurisprudence says in every other context, full compensation means just that, making CSX whole. CSX should be in as good a position after this way of necessity is granted as it was before the way of necessity was granted. The evidence in this case is undisputed. That is not what occurred as a result of the trial court's order. And I want to just point to 4 pieces of undisputed evidence that I think make this quite clear. The first piece of undisputed evidence is it is undisputed that there is a dramatic increase of liability risk associated with a private grade crossing. This particular grade crossing is one where there is a mobile home park on the north side of the track with anywhere from 10 to 12 homes occupied. They're occupied by children, by families, by vehicular traffic, by visitors. And so people are crossing that grade crossing, in Vosica's own words, 40 to 50 times a day. And that's just the ones he's aware of. So you have to imagine all the traffic across that crossing. And as the evidence from CSX makes clear, any private grade crossing poses a risk because it allows vehicular traffic to cross at that specific location. And the court is well aware, accidents occur at grade crossings, unfortunately, more often than they should in this country. Because
under the statutory way of necessity, does that provide for a jury trial on compensation if a party requests it?
It does provide that opportunity for a jury trial, and for that. In this case, neither party requested it.
Well, let me assume that, I want you to assume that one of the parties had requested a jury trial, and you had presented all of the allegations that you're making here about full compensation. You got to include this cost and that cost, and the jury brought in a verdict that, say, corresponded to what the trial judge did here. Would we be in a position to reverse that jury verdict on compensation?
You would, Your Honor, because the issue is competent substantial evidence in that situation. If it's a jury trial, I've never seen this is a rare statute that allows for a jury trial as part of what is essentially an equitable proceeding. So I guess I have to say I've not looked into the standard of review there. But even if it was competent substantial evidence, there is no competent substantial evidence to support a finding that does not place the liability risk on Vosica. Because, again, Vosica did not present any evidence at the trial of any kind that there was no risk. Vosica acknowledges a risk, and in fact, as I'll talk about in a second, the trial court acknowledged that there is an increased risk in this case. So I think the answer to your question is we'd be in the exact same situation with a jury verdict as we would with the judicial verdict we had from the judge in this case. Because
let me tell you where I have a little problem with your position. I want you to help me get to where I'm concerned. People go in, say, in all kind of cases, negligence cases, and they say that a broken arm's worth $50,000, $5,000, and all of these things. But that's generally left, no matter how disappointed one party might be, to the discretion of the fact finder, whether it be jury or by the trial court acting as the fact finder. And it just sort of looks like all these elements went in and he rejected your position, and that's what you call hard luck in the fact-finding process. And I've been there, so I would like for you to address why it is that you think that as a matter of law that we can tell this trial judge that he cannot do what he did by exercising his discretion on the various elements that go into this thing.
Sure, I can address that, and I'll do it in the personal injury context, since that's the context that the court raised. If you look at the cases from this court and other courts, the courts place enormous amounts of discretion within a jury, but when there is a situation where a piece of evidence is undisputed and uncompensated for by the jury, this court repeatedly reverses. For example, in loss of consortium cases, this court has many, many decisions that say that if you can show that your spouse was injured in an accident and you had to go visit her in the hospital, a zero verdict for loss of consortium cannot stand because there's undisputed evidence that you lost some consortium. Now, again, I think once you get beyond the issue of how much, I think if there's disputed evidence, the trier of fact can decide whether a broken arm is worth $5,000 or $50,000. But if I'm in a car accident and I break my arm and it's undisputed that the arm was broken in the car accident and the jury does not return a verdict providing for my medical bills for the broken arm, only provides it for my broken leg, this court routinely reverses those. And I think that's the answer to your question is we're not dealing with a situation here where there was a dispute between the evidence. It wasn't as if we walked into court and said, this is an increased liability risk, and Vosica presented an expert saying, no, it's no different than any other stretch of track along America's highways. This is a situation where the evidence is undisputed, and indeed, beyond that, really undisputable, because the evidence makes clear that the Federal Railroad Administration, the reason this whole thing came about is in order to decrease liability risk associated with private crossings, making a finding, and this is in the record, that private crossings increase liability risk across America's railroad system. And they said to the railroads like CSX, you go out and close 25% of the crossings if you can do that, because we want to protect the safety of citizens and do that. So that's exactly why CSX did this. So again, we have undisputed evidence of liability risk increasing with the presence of this crossing.
And the trial court in this case did order the appellee to contribute a certain amount annually towards the maintenance of the crossing, didn't it?
Exactly. The three elements that we argue should have gone into the compensation. One is the land itself, and the trial court did allocate, I think, $250 for the land itself. The cost of maintenance, because as we make clear in the record, and this is an important point that differentiates this from the average private way of necessity, CSX can't delegate this to Vosica. And so the court said $500 a year which is within the scope of the evidence presented, is the required maintenance fee. And the reason the maintenance thing is important is if I'm just a typical landowner and somebody needs a way of necessity to cross my farm and they want to put a little paved road in, I can say to them, fine, you pave the road, you assume the risk, you do all this. But because of federal regulations, CSX can't just turn the keys to this crossing over to Vosica and say, fine, it's yours. CSX is required to maintain it with its own workers, because of the way the regulations require trained workers, and indeed because it's a deep pocket, will shoulder the liability risk associated with this. And I guess that goes into my next point, which is...
Are they also responsible for the installation of the warning system, and then the appellees pay for that, whatever they install? Who installs the warning system?
Well...
You do, and then they pay for it?
In theory, that is the answer to the question. In fact, that is not. Let me explain the distinction. What the trial court did in this case, the trial court recognized my argument and said, okay, I recognize that the liability risk should be passed from CSX to Vosica. In fact, I'm reading the opinion. I'm quite happy with this. But the result that the trial court reached was, okay, Vosica, you must pay for or reimburse the railroad for the cost of putting in a warning system that meets federal and state law.
So you can decide on whatever warning, I mean, they don't decide, you decide.
No, actually, well, federal and state law decides, and that's the problem with
That's
this.
what I mean, yeah.
Yeah, the problem is right now the crossing meets federal and state law. So what the trial court did is said, Vosica, you pay for something that doesn't need to be paid for. This is a private crossing, unlike a public crossing. If you know, with the cross bucks and the guardrails and the lights and the bells.
Could the judge have ordered something akin to that rather than just say warning system?
I think the judge could have awarded something like that. The problem with his order is it said that meets federal and state law because it already meets federal and state law. If the trial court had come in and said Vosica must pay for a warning system that would meet state law for a similar public crossing with bells, whistles, and the like, I think that would have been probably a discretionary act in the trial court that probably would have passed muster.
And it was made evident to the judge below that it already did meet those requirements?
Exactly. Not only was the evidence in that, but that was the basis for our rehearing motion. And that's, again, that's the irony of all this, is if you read the judge's final order, it really reads as if, almost as if I wrote it the way it, I mean, it's like all the findings I wanted to have in it, you know, until it gets to the remedy. You know, he makes the findings of fact that help us. He makes the equitable finding that the risks should be passed from CSX to Vosica, but then when he tries to fashion a remedy, the remedy he fashions is illusory. It's essentially saying, you know, you do something that's already been done.
And the remedy you want is insurance?
Insurance is the most simple remedy because it's the one that's easy to quantify. Alternatively, you know, some sort of cash payment. We talked about in the record how there was a prior accident at this crossing and how you can get a sense from that crossing what the cost would be. But Vosica testified that he priced insurance and it was $7,500 a year. So that is, I think, the simplest remedy to provide is to do that. I think I'm in my rebuttal time, and I would reserve the rest for my rebuttal. Thank you.
Good morning. My name is Frank Baker from Marietta. I represent Mr. Vosica. He is the dominant landowner. Judge Browning was correct to note that the issue in this appeal is whether or not the trial court abused its discretion. The particular discretionary decision that's challenged in the appeal is the amount of compensation. Under Chapter 704 regarding statutory ways of necessity, the trial court or a jury, if either party requests it, must determine the amount of compensation that's going to be awarded to the servient landowner by the dominant and be paid by the dominant landowner. Unfortunately, the statute doesn't give us a whole lot of guideline about what compensation means. As I looked through the Florida case law on that issue, I did find Stein v. Darby, and it's been discussed at some measure in the appellee's brief. The suggestion in Stein v. Darby is that the measure of compensation is the same measure that you would use in a condemnation case. And I think that's the rationale that Stein v. Darby used in order to find that the statute was constitutional. So what I suggest to this court is the issue on appeal is, under that standard, did the trial court abuse its discretion in arriving at compensation? And in order to reflect upon the trial court's exercise of discretion, I would suggest the following factors are pertinent. One of them is that Mr. Vosica only has one access to his property. This property is 30 plus acres north of a railroad track, and the only way to get to his property is across this grade crossing.
The appellants are not appealing the appellee's entitlement to the prescriptive easement, are they?
That is correct, Judge. Secondly, I would remind the court, as the trial court was reminded, that this grade crossing has been in existence for many, many years prior to Mr. Vosica's purchase of his own property. It was, you might presume, likely installed by the railroad company itself as a grade crossing. It is currently maintained by the railroad company. So the question becomes, under what basis can the trial court be compelled as a matter of law, as pointed out by Judge Browning, to require insurance? Now, what insurance does, as the court is aware, is it shifts the risk of enterprise liability from the actors in the enterprise over to a larger group of people. in this case a general liability policy and a specific railroad commercial liability policy, would shift the cost and the risk of this crossing over to all of the other participants purchasing general liability and railroad crossing liability in the United States, or presumably for this underwriter. Is that shift of that risk appropriate under the circumstances of this case? I would suggest to you that reasonable persons could find, as the trial court did, that it's not appropriate for Mr. Vosica to maintain or to sustain the entire risk of that liability of that crossing himself, for a couple of reasons. And these appear in the record and were the subject of testimony by the railroad's witnesses. First off, the railroad itself has voluntarily assumed the risk of crossing liability in the remainder of its grade crossings, private grade crossings. According to the witness at trial from the railroad, 85 to 90% of the railroad's grade crossings are not permitted. That means that the dominant landowner doesn't have a license to use that grade crossing. It's just used. It also means that the railroad doesn't have liability insurance in 85 to 90% of those grade crossings. They have determined to select a few. And I'm going to suggest to you why they've selected this one in just a second. They've determined to select a few that they're going to isolate and either require grade crossing insurance and commercial general liability insurance, or the crossing is going to be shut down. Secondly, the railroad is determined to self-insure. Now, that's not a minor factor. What that means is they've made the business decision to pass the risk of grade crossing liability not to an insurance company, but to absorb it themselves in their business operation. What that means is that the users of the enterprise are paying the cost of that risk. Contrary to what Mr. Bell suggests, I would suggest to the court that if the court requires as a matter of law that Mr. Vosica assume that risk by the purchase of the liability insurance, the profit or the expense tied to that in the railroad's enterprise gets pocketed by the railroad. So it is indeed a windfall to the railroad. They have in their business decision already absorbed that expense and shifted it among the users of their enterprise. So I would suggest to you that to require that is not only not required as a matter of law, but also not reasonable under the circumstances. Thirdly, I think at trial the railroad wanted to make a big point of the fact that in the 1990s there was an accident at this particular grade crossing. And there's not a whole lot in the record about that particular accident. But we do know a couple of things. One of them is that there were 4 claimants. Only 2 of them had a recovery against the railroad company. So presumably those 2 could not demonstrate that the railroad company did something wrong. That is, that the railroad company was negligent. 2 of them did demonstrate that the railroad company was negligent. What the railroad company wants you to do as a matter of law is to pass the risk of the railroad company's own negligence onto some other shoulders. The policy of that strikes me as not appropriate. I would suggest to the court that the policy ought to be that when a party is negligent, that the party has to pay the cost either of the damages caused by that negligence or of the risk and the shift of that risk to somebody else. To suggest that Mr. Vosica, as a dominant landowner, has to pay the cost of the risk of ensuring the railroad's negligence might serve as well as a disincentive to the railroad to maybe be as careful at this crossing as it might otherwise be.
Counsel, this is a purely private crossing.
This is truly a private crossing. There was some discussion with the local governmental authority about taking the crossing over, and this just did not serve a sufficient public purpose to justify that. So the local, I think it was the city of Chipley, the local city declined to take on the crossing. So it's truly private, Judge. I think we need to get back to what the issue is before this court. Did Judge Register abuse his discretion in determining that here's what I'm going to have Mr. Vosica pay: the value of the land, the cost of maintenance of this particular crossing, and he assessed 100% of the cost. And I'm going to require him to make sure that the crossing signals there meet minimum state and federal guidelines. Now, I understand the railroad's position that it now has discovered that the crossing that's there already meets those guidelines. But, you know, this is a ruling that is into the future also. So if at some point in the future the railroad crossing guidelines require additional crossing guards or signs or lights or cross bucks or bars or that sort of thing, then presumably the railroad has the right to come back into the trial court and say, listen, the requirements have now changed. Mr. Vosica ought to meet those new and amended requirements. So this is not a useless provision in the trial court's order. It is just something that doesn't require compensation as we sit here today. I also get the sense, and I don't mean to suggest anything wrong of Mr. Bell or the railroad, but I get the suggestion that it is important to the railroad that this costs Mr. Vosica something. And I would urge the court to move away from how much does it cost Mr. Vosica to what is compensation for the railroad. I think that's what 704 requires. I think that's what Judge Register did, and he did so within the realm of the evidence. And reasonable persons could decide that because of the risk of liability already being undertaken by the railroad at this crossing, because they have the ability to and have shifted that to all of the users of their enterprise, that it's not reasonable to require Mr. Vosica to pay that. I would ask that this court affirm the trial court's determination.
Counsel, you've indicated that the railroad is self-insured in terms of this particular crossing. Is that correct?
Yes, sir.
And this is a purely private crossing?
Yes, sir.
At this point. How does maintaining or insuring costs, i.e., as a self-insurer, benefit the railroad in terms of the purely private crossing?
Well, it doesn't as this particular crossing, but the railroad has 85 to 90% of its private grade crossings that it maintains without any compensation at all from anybody. So what it's done, Judge, is shift the risk of all of the private grade crossings to the users of its enterprise, not just this particular one. I guess my point in saying that is that this is not the exception to the railroad's rule. If the trial court required insurance, that would be the exception to the railroad's own rule. The railroad itself has established the ground rules in this case, and it's not unreasonable for the trial court to have said, listen, those are the ground rules. I'm going to require the landowner to pay compensation for the land, pay the cost of maintenance, and make sure that the crossing meets state and federal guidelines.
Would it have made any difference had the railroad retained an outside insurer to insure this crossing in question?
Judge, I didn't hear the first part.
Would it have made any difference if the railroad had retained an outside insurer to insure this crossing in question?
I don't think so, Judge. In my view, the policy behind shifting by way of insurance or shifting to the enterprise cost by way of self-insurance probably is the same. I just think, I don't want the court to believe that Mr. Vosica is getting windfall. If Mr. Vosica has to provide this insurance, it's the railroad that's off the hook, and the cost that it is shifted to its enterprise users goes into the railroad pocket. It doesn't go into the enterprise user's pocket. Thank you.
Rebuttal.
There's a hint of irony, I think, in the argument that Mr. Baker makes about the shifting of risk and how CSX is self-insured and so many crossings across the system are uninsured. The implication almost as if, well, you've accepted risk somewhere else, you should be stuck with the risk everywhere and can't do anything about it. And that's not exactly what the law should be in this situation. Again, the evidence is undisputed at this point. CSX wanted to get rid of this crossing and therefore would have eliminated its liability risk. It would have ceased to exist. And the only reason this crossing is in place today is because Vosica filed the lawsuit and the judge granted the statutory way of necessity. Now, we've not challenged the ruling on that. We don't care for it, but it's supported by the evidence. So we didn't challenge that ruling. But to suggest that CSX therefore has to provide this crossing in perpetuity and to assume all the risk that is undisputed about the liability it just does not comport with common sense. This case has larger implications than this one dispute. As the record makes clear, the Federal Railroad Administration has directed CSX to try to do these types of closures, and these issues are cropping up other places. And in fact, the Nevada decision in the Pewitt case, which I cited at length in my opinion, in my brief, I think has really, really helpful language and explains this in the context of shifting liability and risk there. Now, the facts of Pewitt are slightly different than our case, but the policy from the decision is exactly the same. And what the court there said is that if you have a person who needs a private crossing for his own use, then equity requires that he be the one to pay for the liability risk associated with that crossing. And the court says on page 217, a ruling in Pewitt's favor in effect entitles all other current servient owners of land along the railroad's track to require the railroad to bear the expense of maintaining and ensuring any private crossings upon those lands. To pose such a financial burden on the railroad is unwarranted and inequitable. That's at page 18 of my initial brief. That's exactly what we have here today. We're simply asking for a rule that says CSX is in the same position now that it would have been if this crossing had not if we'd been allowed to take the crossing out. We don't want the crossing. We don't need the crossing. We don't use the crossing. Vosika is the one that wants, needs, and uses the crossing, and if he's the one that wants, needs, and uses the crossing, he ought to be the one to pay for the liability risks associated with that crossing, whether it be in the context of insuring it or the context of helping CSX to build up a fund for self-insurance purposes, or even in the context of providing additional safeguards that go beyond what is required by current federal and state laws. Those are the discretionary items the court could have reached. But to decide that
require the appellees to pay 100% of the annual maintenance cost of the crossing.
I missed the first part of that. I'm sorry, Your Honor.
The trial court require the appellees to pay 100% of the annual maintenance cost of the crossing.
The evidence at trial was it would be $500 to $700 a year. He chose $500. It was within the evidence. I think you could argue it wasn't 100%, but it was in the ballpark of 100%. And so we believe that a rule, the way the trial court fashioned it, is inequitable under the circumstances. Therefore, we think the case should be reversed. Thank you.
Thank you. This concludes our docket for this morning. We're going to stand in recess. Thank you.